Tell us, please. Tell us. Yes.
My Lordship. I'll just place the facts, Your Lordship. After that, I will go through the question of law.
All right. All right.
Lordship, in the 1987, the present petitioner, who was in exclusive possession of the disputed land, made an application bearing registering case number 95 of 87 for settlement of the disputed land on lease before the Tehsildar Banpur. Subsequently, my Lordship, on 20/10/1987, the revenue inspector inquired into the matter in presence of the local gentleman and submitted its report, stating therein that the petitioner is in physical possession of the disputed land plots before the year 1962. Subsequently, my Lordship, in the 1987, I should mark it, this is important, the Tehsildar Banpur, by order dated 28/11/1987, settled the disputed land in favor of the petitioner on lease principle with the direction that the petitioner has to pay salami and back rent from the 1974. Subsequently, my Lordship, the ROR was corrected in the name of the petitioner, my Lordship. In 1992, my Lordship, the OP number 4.
Not reached.
You've sent the list of dates by WhatsApp or?
Yes, Your Lordship. Actually, I have sent it through our clerk.
We'll just pass it over, sir. You just send it by WhatsApp so that he can print it out.
I beg apology. I will send it to WhatsApp, Your Lordship.
So just pass over.
My Lordship.
Who's for the state? Who's for the state in this?
Item number 1.
3.
Sir, I-
Three.
I am appearing for the
3. I am for the state.
endowment.
My lord, I am for the state. Item number 3.
So he'll send you also. You have the list of dates.
No, I
No,
don't
I-
have copy.
So you please send it to Mr. Manthi also.
I am also appearing for the opposite party number. For the,
Oh, I see.
the Bhagavati endowment, it's an endowment property.
Oh, I see. I see. All right, sir. All right. So we'll just pass it over. Yeah.
Item number 4.
None appears. This was not.
Item number 4, Malsa, I am appearing for opposite party members.
All right. Put us in the appearance. All right.
Item number 5.
Again, none appears. This was not discussion.
Item number 6.
None appears. This was not discussion.
Item number 7.
My lords, permitted to be withdrawn, my lords, with
Ah.
liberty to.
No liberty, sir. It's a 1998 matter. Answer to the petition is leave to withdraw this petition. Dismisses.
Item number 8.
None appears. This was not discussion.
I am for the opposite party corporation.
All right.
Item number 9.
None appears. This was not discussion.
Item number 10.
May I please, my lord?
Yes.
The petitioner is a small scale industry, my lord.
Yes.
Annexure 1 is the permanent registration certificate in favor of the industry.
Yes.
Page 11, my lord. Annexure 1, page 11.
Yes.
It is located in a Gram Panchayat area, and the finished product is aluminum utensil sheets and alloy ingots and all that. And then the sales tax registration certificate is an Annexure 2 series, where the raw material is at page 15. Starts at page 12 and relevant portion at page 15. The raw material, clause A, my lord.
Yes.
The raw material is aluminum ingot. For my finished product, the raw material required is aluminum ingot. That I am supposed to buy it from the Nalco, my lord, which almost had a monopoly in respect of the sale of aluminum ingots. And since under the Act, I am not liable during that period till 24/11/2000. I was not liable to pay.
So there is no interim order here.
Right.
So this is about payment of entry tax, correct?
Here my limited point is the collection made by Nalco till 24/11/2000, not beyond that. After that, it was amended. So for that period of 47,000, which was collected by Nalco, was
Sir,
without authority.
This 47,000 after this many years, what does it matter, sir? This is not a matter for which we should interfere. There is no stay order, nothing.
Collection is without authority of law. Only thing is that collecting.
Leave that question open, sir. 47,000 is not an.
In the counter affidavit, they have not disputed. The state has not filed any counter affidavit. They also say that they have no dispute with regard. They only protect in the, your lordship may just have a glance with regard to that circular, my lord. Annex 3 of the circular by the government, additional commissioner at page 16.
What is NALCO stand?
NALCO is agreeing to that. Well, your lordship may see the counter affidavit given by the NALCO. Relevant person, my lord, para 5. Internal page 3, para 5.
Yes.
That it is submitted on behalf of NALCO that it has no objection whatsoever from accepting the declaration from the petitioner in the form as approved by the CTO under cover of his letter under Annex 1 by C, and also to give force to the letter of the additional commissioner dated 25/5/2000 by Annex 1 by A, subject to the direction of this honorable court, in order to safeguard itself from any adverse orders of demand from the entry tax or officer or fixing of entry.
So now you're asking for refund of this entry tax amount.
Because since it was collection is without authority of law, as a consequential refund, 47,000. Your lordship may see, then next para 6, that it is most respectfully submitted. NALCO had no adverse interest whatsoever, contrary or in conflict with the interest of the petitioner. That they have said.
And the state has not filed a counter.
No, man.
All right.
Who's for the state exempted?
No, accepted where?
No, state exempted. The act is exempting me from payment of state.
I see. Yes, Mr. Mudali, are you appearing?
No, my lord, department is there.
Who's there? Mr. Mishra.
I am appearing on behalf of NALCO, my lords. The petitioner in this case filed an additional affidavit, and we have filed a reply to that affidavit on 11/1/2020. And that has not been got on the. My lords,
I have got a copy of the reply affidavit to
yes,
my additional affidavit.
Just a moment. Sir, my lords, in that counter affidavit, which is admittedly not in record, my lord may be permitted to place paragraph 2. May I permitted to place that, my lord?
Yes.
That it is respectfully submitted that whatever collection has been effected on account of entry tax by the opposite party number 1, that is NALCO, from the petitioner, had been duly deposited with the sales tax officer, Cuttack 2, Circle, Cuttack, who is
so he will apply for refund there, sir.
Yes, my lord. Yes,
all right. The short point involved in the present petition is regarding the liability.
One second, my lord, just a second. I cannot ask for a refund, my lord, because they have deposited. They have collected from me and deposited. I cannot ask for a refund unless you
under the order of the court. They will give it to you, sir.
Yes, my lord. Yeah.
The short point involved in the present petition concerns the liability of the petitioner to pay entry tax on purchase of raw materials from NALCO opposite party number 1. Paragraph. The petitioner states that it set up a small-scale industrial unit at village Bandalu in Kotsahi Gram Panchayat, district Cuttack, under the Industrial Policy Resolution 1996, IPR 1996, for manufacture of aluminum circles, sheets, utensils, etc. It has also got a registration under the Orissa Sales Tax Act 1947, OST Act. For the purposes of its industry, the petitioner used to purchase aluminum ingots from NALCO from its plant at Angul in Orissa. It is stated that aluminum ingot is goods specified in Part 1 of the schedule to the Orissa Entry Tax Act 1999, OET Act. It is stated that in terms of Rule 3, (4) of the Orissa Entry Tax Rules 1999, OET rules, aluminum ingots used as raw material on first entry in a local area, other than a municipality or municipal corporation or notified area council, shall not be exigible to entry tax. It It is further pointed out by a circular dated 25th May 2000, the Additional Commissioner of Commercial Taxes, bracket General, bracket Orissa, directed NALCO and the Rourkela Steel Plant and other manufacturers to allow the benefit of the concession granted under Rule 4 bracket or Rule 3 bracket 4 of the OET rules to the purchasing manufacturer after obtaining a written undertaking to the effect that they satisfy the norms, and further that they would be liable to pay the entry tax in the event it is found that they are not so entitled to the benefit. Paragraph. The petitioner, by its letters dated 7th and 28th June 2000, intimated NALCO that its factory was not situated either in a municipality or a NAC, but in a Gram Panchayat, and therefore no entry tax should be charged. Full stop. The petitioner also furnished an undertaking as required by the circular dated 25th May 2000 to NALCO. Paragraph. The petitioner states that notwithstanding the furnishing of the above undertaking, NALCO proceeded to collect entry tax on the purchase of aluminum ingots by the petitioner. In an additional affidavit dated 4th April 2001, the petitioner has set out in para 3 the details of the entry tax collected by NALCO at the rate of 1% on sale of aluminum ingots as under. Take from para 3, page 35, the table paragraph. It is therefore contended that the aforementioned sum of rupees 47,969.26 collected from the petitioner as entry tax ought not to have been collected, and that the aforementioned sum is in fact refundable to the petitioner. Paragraph. Despite notice in the petition having been issued way back on 24th August 2000, only NALCO has filed an preliminary counter affidavit and a further reply to the additional affidavit, in both of which the contention of the petitioner is not contested. In other words, there is a categorical statement in para 5 of the preliminary affidavit of NALCO as under, reproduced whole of para 5 at pages 28 and 29. Further, in para 6 of the same affidavit, NALCO is stated as under, reproduced para 6. Paragraph. In addition, in reply to the additional affidavit of the petitioner, NALCO has confirmed that the entry tax collected by it from the petitioner has been deposited by it with the state of Orissa. Paragraph. As already noted, for more than 2 decades now, no reply has been filed to the present petition, and therefore the court proceeds on the basis that the averments of the petitioner remain uncontroverted. Paragraph. With the petitioner's assertion that it has fulfilled the requirements of the circular dated 25th May 2000 of the ACCT and has furnished the requisite undertaking. And further, its assertion that since its factory is located in the Gram Panchayat area, it is exempt from payment of entry tax, has remained uncontroverted and in fact accepted by NALCO. The court directs that on the strength of the present order, it will be open to the petitioner to apply to the opposite party state to seek refund of the aforementioned sum of rupees 47,969.26, which has been collected from it by NALCO and deposited with the government. Stop. Since there is no dispute that the aforementioned sum has in fact been collected from the petitioner, there should be no difficulty in the refund being made to the petitioner by NALCO on the strength of the present order, by the state government on the strength of the present order. Paragraph. if the application for refund is made by the petitioner to the government not later than 14th February 2022, it will be processed and the aforementioned sum, together with whatever interest is due thereon, in terms of the OET Act and rules, will be made to the petitioner by the government within a period of 4 weeks thereafter, and in any event not later than 15th March 2022. If there is any delay in making the refund, the state government will be liable to pay the petitioner an additional interest of 6% per annum, simple interest per annum for the period of delay. The petition is disposed of in the above terms.
Obliged.
Item 11.
May I please, Your Lordship? The impugned order is at Annexure 5, page 19. By the impugned order, the tribunal directed the state government to count the past service of the applicant from 23/11/1972 to 17/7/1982.
But there is no stay of the order, sir.
No, there is no stay. My lord, only notice was
So we
issued.
leave the question of law open. You say, although notice was issued in the present petition filed by the state government against an order dated 21st April 1999 of the Orissa Administrative Tribunal, Bhubaneswar, packet OAT, on December 2004. No stay was granted of the said order till date. In fact, the petition was thereafter listed only twice. Paragraph, in terms with the impugned order, the OAT has directed that the state government should count the entire service rendered by the opposite parties in the private colleges prior to takeover of the said college by the government for the purposes of eligibility for promotion to the post of reader. Full stop. With there being no interim stay of the said directions, it ought to have been implemented by now by the state government. Full stop. The effective operative portion of the impugned order is that the past service of the opposite party from 23rd November 1972 to 17th July 1992 rendered in the
17th July 1982.
82, all right, rendered in the non-government aided college should be counted for the purposes of promotion to the post of reader. Paragraph. Given the limited nature of the direction and the fact that there has been no interim stay, and that the said order has remained in force for over 2 decades, this court is not inclined to interfere with it at this stage. However, the question of law arising from the impugned order is left open for decision in some appropriate case. The petition is disposed of.
Item number 12.
None appears. Dismissed for non-prosecution.
Item number 13.
Item 13, Your Lordship, Mr. Rautra is down in COVID, Your Lordship. For that
It's all right. Tell us what the matter is about, sir. This is 2002 matter.
Yes, Your Lordship, I am unable to get the brief because the house is on quarantine. He is in quarantine. So I am.
Who's for the other side? 1 minute. Who's for the other side?
The state is on the other side and other private.
Let us find out who's on the other side, sir.
My lord, I am for the other side.
What is the matter about? You tell us.
That file is also not traceable. One pass over may kindly be. I'm
all right.
One
pass over.
Item number 14.
May I pray for Lordship? The petitioner is a workman joined with the opposite party to head office in 1978. Then he was given some benefits by an agreement, individual agreement in 87, but violating those terms, the from head office, he was transferred to Jharsuguda factory, that is railway sleeper factory of the company.
So this OCP India Private Limited is still around?
My lord, Orissa Concrete Products.
Huh?
My lord, the opposite party too has not yet appeared, my lord.
So what are you going to get, sir, out of this whole petition? What was the prayer in the before the tribunal?
My lord, may I place the facts shortly, my lord?
If they have not been served, what relief are you going to get, sir?
My lord, when the dismissal is without giving natural justice and the domestic inquiry is not fair, and inquiry, before inquiry, the document.
Sir, if you do not know if opposite party number 2 is still functioning as a unit.
Yes, my lord. Yes, functioning.
When did you find out, sir? This morning or yesterday evening?
No, my lord. I am regularly in touch of those workers' union, my lord. CI2-led union.
Okay. Show us the award, sir. Show us the award.
Award, my lord.
Annexure 19.
My lord, there is two. One is order under section 10(1) of the IDEA. Another is an approval order under section 33(2)(b) of IDEA, my lord.
Let us read the award, sir. It is not a very detailed, it's not a very complicated award. You can read it, sir. Page 123.
Before going that, my lord,
the facts are set out in the award itself. If you read it, we will also understand it.
The last one, my lord, award under.
Correct.
I am placing the award.
You all right.
Running page 122.
Yes. So this Mr. PC Pradhan, what is his age now, sir?
He is now 68, my lord. Already retirement age he has passed in 60.
All right.
My lord.
Please read para 2 onwards.
Para 2, my lord. The claim of the second party workman in brief is that he was a permanent employee of the management company being appointed on 21/1/78. He was working in the head office at Bhubaneswar. In 1987, he wanted to resign from service, insisting to continue only at Bhubaneswar till his retirement. So an agreement was entered between the parties and the second party on 25/9/87, incorporating the above agreement, and thereafter he continued to work at Bhubaneswar until 17/2/93, when he was transferred to Jharsuguda. Since this transfer was illegal, violating the above agreement, he made a protest. The management assured to look into the matter, and second party started working at Jharsuguda, and by an order dated 7/12/95, he was again transferred to Guwahati, Assam, to work in a different company, namely Messrs. Rungta Agency Private Limited, completely a different organization. So the second party filed a title suit number 596 and miscase number 4 of 96 against the management and others in the court of civil judge senior division Sambalpur, trying to declare this transfer to Guwahati as illegal. In that miscase, the civil judge directed the management to maintain status quo of the workmen until further order. Both the cases were adjudicated sub judice. In view of such injunction order by the court, the workmen joined in service at Jharsuguda on 22/11/96. On 17/4/96, he was put under suspension on false charges. On 25/5/96, the management issued additional charge making false allegation against him. The workman demanded certain documents to give reply, which he was turned down. Thereafter, the workman submitted explanation on 23/12/96. But before receiving this reply, the management appointed S.K. Mahanti to inquire into the matter as per the charges drawn against him. this inquiry officer who is a retired officer of that company, my lord. The inquiry officer sent notice to the workmen to participate in inquiry. He made a representation making for documentation, asking for documents and to stay the inquiry till disposal of the civil cases. But the inquiry officer concluded the inquiry in his absence. On 22/4/97, he received dismissal order dated 19/4/97. From that order, he could know that the inquiry officer held the inquiry expertise and gave a finding against him. He was not supplied with the copies of inquiry proceeding and finding. The second party claims that after the status quo order from the court, the management pressurized his officer, D.K. Rai, who signed the agreement dated 25/9/87 on behalf of the management to deny making such agreement by answering on affidavit which Sri Rai did. He has been dismissed from service in vindictive manner. After his dismissal, he raised an industrial dispute before the DLO Jharsuguda. The conciliation officer and the labor officer submitted failure report to government, and accordingly the government referred the matter to the tribunal for adjudication, hence praying for reinstatement with back wages and promotional benefits. 3. In reply, the first party management submits that on 18/4/96.
Sir, what will happen is at the highest, this has to go back to the tribunal for a fresh disposal because they have not gone into the merits of the dismissal. They've only said that the tribunal seems to think that you should have availed the alternative remedy of appeal and therefore it cannot examine.
Not only that, my lord, before that, the management came to this honorable court for adjudication, joint adjudication, clubbing those two matters, my lord, 33(2)B and 10(1) reference, my lord. But the tribunal also didn't implement it. And in the first case, he held that the inquiry is proper. In the second case, he held that the reference is not maintainable. And because he has held the inquiry proper, so the dismissal is legal and justified. That is the whole matter, my lord. We have not been given inquiry papers, my lord, not able to defend, my lord. The second show cause notice.
So what will happen is we'll only send it back to the tribunal with the notice not having gone to the management. I don't know when they will appear there.
Discretionary power, my lord, your lordship discretionary power in case your lordship transfer and redirect for again adjudication, my lord. I will pray it should be at Bhubaneswar Industrial Tribunal because the workman is now under treatment at Bhubaneswar. Otherwise, there is also a power your lordship behind. Your lordship can grant some compensation, my lord, and close.
No. Sir, all that will be on paper. Nobody has appeared for the management. You will only be running around in circles. You will get no money.
My lord, they are not appearing intentionally because they.
So you will have to go under 33C for implementation then.
What implementation, my lord?
If we give you an order today,
yes,
that you have to be compensated, let's say X amount.
Yes.
How will you recover that amount, sir?
They will pay, my lord. Otherwise,
I see. Immediately they will pay. Without notice, they have not been heard in this matter. They will pay.
With all
they will obviously not pay. You have such vast experience, Mr. Das.
No,
if the management is also abiding of rule of law, you will not be here, correct? So you will have to go under 33C for implementation.
And if your lordship will direct, we will go for implementation.
We don't have to direct, sir. Law is there. What I'm trying to tell you is whatever order we may pass, it will only be on paper. You will anyway have to run around in circles for implementation. It is better to have a contested matter properly contested.
My lord, pardon, my lord, your lordship know the whole industrial dispute is to unequal battles, my lord.
Sorry?
Always the workers are, all the workmen are suffering.
Sir, if we had money to give, then no need to depend on any management to become a charity.
Your lordship
we simply ask government to pay. We cannot, right? There is a law. You are seeking compensation from your management, correct?
My lord, your lordship may direct the opinion number 2, my lord, to pay.
Yes. Let us say we ask them to pay you 5 crores of rupees. All right.
That will be again.
Will you get that money, sir?
My lord, I will go on my pet, my lord. Your lordship may pass some
This is not a Lok Adalat, sir. Please. This is not a local Adalat. If your ground is that the tribunal has not gone into the merits of your dismissal, we can only send it back to the tribunal for adjudication on merits.
And I abide by your decision. Your lordship may direct it to adjudicate at Bhubaneswar Industrial Tribunal.
All right, all right.
My lord. Within a stipulated period, my lord. Both the cases, my lord, 33C2 and 10-1. That was the previous order of this honorable court, my lord, which the Industrial Tribunal.
Where is that previous order, sir?
Previous order in that is, I have quoted in the writ petition, my lord. Possession number 6604 of 2000.
There are two writ petitions.
I am placing the order, my lord. May I place the order last paragraph, my lord?
You filed only one writ petition, sir.
My lord?
Have you filed two petitions or one? You have filed only one petition. You have filed only one petition, sir.
Yes, my lord. This 66.
And the challenge is only for this. Oh, in one writ petition, you have challenged two orders.
My lord, my lord.
Aha. That is permissible. No problem.
My lord.
Single writ petition for two orders.
My lord.
Everything is, sir, this magic word, my lord, means we don't know if it's yes or no, nothing. Everything you keep saying, my lord.
My sir.
When I ask you a question, you will say, my lord.
Previously, opinion number 2 came to this honorable court for clubbing those two cases in Industrial Tribunal in a writ petition 6604 of 2000.
Where is that previous order? Where have you quoted it?
My lord, we have quoted in the body of the writ petition.
Page 15.
My lord. Oblige. Yes, page 15. May I place it, my lord?
That's okay, we are reading it.
Last paragraph, the writ application is thus disposed of by directing the Industrial Tribunal Raurkela to hear the industrial dispute case number 22 of 99 and ID miscase number 145 of 97 together. The tribunal is also directed to dispose of the case as early as possible, preferably within 3 months from the date of communication of this order.
All right.
This is not also.
Challenge. All right, sir. All right. The challenge in the present petition is to two orders of the Industrial Tribunal. Rourkela, bracket Tribunal. The first order is dated 25th September 2001. In Industrial Dispute Case number 22 of 1999, where the question was whether the domestic inquiry conducted by the management preceding the dismissal of the petitioner workman was fair and proper. No, what I said, sorry. The challenge is an order dated 20th August 2001, passed by the Industrial Tribunal Rourkela, bracket Tribunal, in ID miss case number 145/1997, holding that the domestic inquiry conducted by the management prior to dismissal of the workman was fair and proper. So this was in a miscase petition filed by the management for approval of its action. Paragraph is the petition also challenges the subsequent award dated 28/12/2001, passed by the tribunal. In district dispute case number 22 of 1999, upholding the dismissal of the petitioner by the management on the ground that the workman should have availed of the remedy of appeal against the order of dismissal in terms of the certified standing order. Full stop. Paragraph. Despite notice in the present petition having been issued way back on 13th November 2003, and with the office report being that the notice was returned on valid service, none has appeared for the opposite party number 2 management till date. Paragraph. This court has heard the submissions of learned counsel to the petitioner. Paragraph. The court's attention has been drawn to an order passed by it on 7th August 2000 in OJC number 6604 of 2000, filed by the opposite party number 2 management, seeking analogous hearing of ID miss case number 145/1997, bracket under section 33 bracket 2 bracket small b of the Industrial Disputes Act 1947 bracket ID Act bracket, and ID case number 22 of 1999, which was a reference made at the instance of the petitioner employee workman against the order of dismissal. Full stop. The said order dated 7th August 2000, passed by this court, reads under. Reproduce the order at pages 15 and 16. Paragraph. It is seen that despite the above order, the tribunal did not hear the 2 matters, namely ID miss case number 145/1997 and ID case number 22 of 1999 analogously. It chose to pass a separate order on 20th August 2001 in industrial waste case number 145/1997, holding the domestic inquiry to be just and proper. Full stop. It passed a separate order on 28th December 2001 subsequently, upholding the petitioner's dismissal from service for the reasons already noted. Paragraph. The court therefore finds that the tribunal has acted contrary to the specific direction issued to it by this court in OJC number 6604 of 2000 by its order dated 7th August 2000. On this short ground, both the impugned orders of the tribunal require to be set aside. Stop. In any event, the court finds that the award dated 28th December 2001 fails to examine the merits of the dismissal order. Stop. Once the reference was made, the question of rejecting the plea of the workman only on the ground that he did not avail of the remedy of an appeal under the standing order did not arise. Also, it was incumbent on the tribunal to have decided the issue on merits. Paragraph. For all of the aforementioned reasons, the orders dated 20th August 2001, passed by the tribunal in ID miss case number 145/1997, and the award dated 28th December 2001 in ID case number 22 of 1999 are hereby set aside, and both matters are remanded to the tribunal for a fresh disposal in accordance with law. Paragraph. At this stage, counsel of the petitioner states that the petitioner workman is now 68 years old And the only relief, even if he succeeds, would be that of seeking compensation and arrears of salary. Full stop. He points out that the petitioner is presently located in Bhubaneswar and it might be difficult for him to pursue the matter at Rourkela. Paragraph in the circumstances pointed out herein before by the counsel of the petitioner, the court directs that both ID case number 22 of 99 and ID miss case number 145 of 1997 shall stand remanded to the Industrial Tribunal at Bhubaneswar. Full stop. The records of the case, have the records come here?
No.
The records of the above cases will now stand transferred from Rourkela to Bhubaneswar for the above purpose. Copy of this order be sent to the presiding officer of the Industrial Tribunal at Rourkela for doing the needful. The case will now be listed before the Industrial Tribunal at Bhubaneswar on 7th March 2022 for being proceeded with in accordance with law and for strict compliance with the earlier direction issued by this court on 7th August 2000 in OJC number, give the same OJC number. Considering that the matter is an old one, the tribunal at Bhubaneswar is directed to dispose of both cases after hearing the parties, not later than 3 months thereafter, and any event not later than 6 June 2020. The petition is disposed of in the above terms.
Obliged.
My lord, item number 13 that was passed over, we have filed the counter affidavit in that case also, and matter is ready for hearing. Item 13, that is a order against the order of Board of Revenue under section 38B, and the lease is found to be fraudulent and irregular. That is why that was cancelled in exercise of power under section 5I of the Act. So that order the petitioners have challenged. The land is 25 acres of land in Bhadrak.
No, there's no stay here, or there is a stay?
No, there is no stay.
Then have you taken over the land or not? No, status quo is there, sir.
Status quo is there, your lord.
Oh, status quo, yes, status quo is there.
19 November 2007, status quo is there. So this is where he's suffering from COVID.
Lordship, let it be 10 days after I apprise your lordship.
All right. Counsel, the petitioner is stated to be unwell. List on 21st February.
Deeply blessed. Interim update to continue.
Yeah.
Item number 15. Item 15.
None appears. All matters.
Right.
Dismissal now.
Item number 16.
None appears. Dismissal number.
Item number 17.
Lordship, item 17 has become infructuous. The same.
Infructuous. These are
all right. Counsel, the petitioner states that these petitions have been rendered infructuous. Disposed of us.
Item number 18.
My lord, this case has been infructuous.
All right. Same order. Yes.
Item 19. Item number 19.
Item number 19. This matter.
Yes.
The petitioners, they challenge the order passed by member Board of Revenue.
No, Mr. Ratha, that there's a noting that you were to take fresh steps for opposite party number 4.
Oh, I'm so sorry, my lord. I had not seen that. I'm so sorry. Yes. I'll have to take it by tomorrow, my lord. By day after tomorrow.
No, but is the issue alive?
But it's a property dispute.
There's no. The court refused to stay the order.
Yes, there is no stay order.
The stay order is not there, but then my right over the property still remains. So your lordship is to decide the issue either way. So I'll pray the honorable court to grant me 2 days time to comply with the notings. Come back to your lordship 10 days after, 2 weeks after, any time you
We don't even know if these people are around. Nothing we know. All right, Mr. Rathas, it is seen that.
I also understand. But then the client's satisfaction somewhere will have to. And now that everything is
not removed, sir, defects not removed for 18 years, 17 years.
I'll do that, Milord. I in fact didn't know it. Within a day or two, I'll do it.
The officers pointed out that the defects pointed out have yet not been removed. In particular, opposite party number 4 is yet to be served as the address given was not proper. Mr. Ratha, the better thing is to dismiss it for non-prosecution. You get it restored after finding out his address.
Because whether he's alive or not, that is.
Should I make a statement? Should I make a statement? Let me take instruction. If in fact he is not there, then
exactly. Whether he's
let me
alive
take
or
one
not.
instruction. Give me one time instead of all these matters.
All right. You just say at the outset, you said Mr. Ratha seeks 1 week's time for instructions.
Yes.
At his request list.
Since they are pro forma opposite parties, I may ensure their presence before your lordship. Pro forma, they are all my brothers.
Anyway, you make a statement, sir.
Yes.
We'll keep it for 2nd February.
Yes.
Item number 20.
No instruction.
Counsel, the petitioner states he has no instructions. Disposed of.
May call that pass over of the old matters. Pass to old matters. Item number 3.
I believe, my lordship, you have received the copy of the list of dates, your lordship.
We have.
Yes.
Yes, your lordship. I will again place the list of dates, your lordship.
Yes.
It is relevant for the facts to be considered, your lordship. In 1987, my lordship, the present petitioner, who was in exclusive possession of disputed land, made an application bearing listing case number 95 of 87 for settlement of the disputed land on lease before the Tehsildar Banpur. Thereafter, my lordship, on 20/10/1987, the revenue inspector inquired into the matter in presence of the local gentleman and submitted his report, stating therein that the petitioner is in physical possession of the disputed plots before the year 1962. Master, can mark this point, 20/11/1987. The Tehsildar Banpur, by its order dated 28/11/1987, settled the disputed land in favor of the petitioner on lease principle, directing that the petitioner has to pay the salami and back rent from 1974. Thereafter, my lordship, in 1987, the ROR was corrected in name of the petitioner. And thereafter, he was also paying the salami. In the year 1992, after expiry of 5 years, the OP number 4, which is the, my lordship, the endowment, has filed an application purported to be under section 6 and 7 before the OEA collector, Banpur, for the settlement of the disputed land. Thereafter, my lordship, on 27/6/1992, the OP number 4 again filed a petition for review under section 38A of the Orissa Estates Abolition Act for review of the order dated 20/11/1987, passed in visiting case number 95 of 87. And by the order dated 27/6/1992, the additional Tehsildar cum OEA collector settled the land in favor of the DT instead of the present petitioner behind his back. Thereafter, your lordship, on 22/8/1995, the OP number 4 again filed a miscase bearing OEA miscase number 1 of 1995 before the additional Tehsildar Banpur, the same authority, your lordship, for setting aside the order dated 27/6/1992, passed in OEA case.
But tell me, why would they ask for setting aside? That's an order in their favor.
My lordship, that is the point, your lordship. My lordship, before proceeding with the merit of the case, your lordship, I should kindly see 38A.
No. Just explain to us, why would they file a second miscase for setting aside the 1992 order? If it's in their favor.
That is the point, your lordship. In 38A, I should consider 38A.
Estate Abolition Act.
Yes, your lordship.
Yes.
38A states review, Your Lordship.
Yes.
Any decision made or order passed under this act, whether before or after the commencement of the Orissa Estate Abolition Amendment in 1973, other than a decision or order against which an appeal or revision has been preferred under this act, may within 1 year, the limitation period is 1 year, Your Lordship, within 1 year from the date of the decision or order, as the case may be, and after giving all persons interested an opportunity of being heard, be reviewed by the officer who made the decision or passed the order or his successor in office on the ground that there has been a clerical or arithmetical mistake in the course of this act. My humble submission is, Your Lordship, if the OP number 4 is agreed by the order of the Tahsildar under Annexure 1, the recourse is revision under 38B, not 38A. 38A review states only on the ground that if there has been a clerical or arithmetical mistake, nothing more than that, Your Lordship. Now, what they have done is, my Lordship, under Annexure 3, which I have also challenged at page 31 and 33, Your Lordship.
Yes.
31 Annexure 3, Your Lordship. They have recalled their own order under 38A, Your Lordship. Let me just place the first paragraph. The case is put up today. The executive officer, Sri Daksheshwari Bhagavati Endowment, Banpur, has submitted a petition for review of the order passed by the OEA collector Banpur in OEA case number 95/87 and to settle the land in favor of the DT. My first point of submission is, my Lordship, it is impermissible under 38A.
No. So why did they file a further case in page 33?
Yes,
They
Your
filed
Lordship.
another
Just Annexure 3, my Lordship, it will be clear. Why it has been again they filed a application for review. My Lordship, kindly see the next page, 32. It starts with Banpur. As per last settlement held in 1961, since this is a trust property, the name of the recorded tenant cannot be changed. That means the petitioner, Your Lordship. Hence, the right title and composition is suggested in favor of the DT, Sri Daksheshwara Bhagavati Mufaddar Trust Banpur. Since the original case record is not readily available and could not be traced out, so no correction to the ROR should be made. Even though there is a suggestion that the should record the name of the DT, the same was not done because the case record was not available, Your Lordship. Subsequently, they filed another application for review under Annexure 4, Your Lordship. Annexure 4, page 33, Your Lordship.
Yes, we're on that.
Yes, Your Lordship. Again, an application for review was filed, wherein the OEA collector, additional Tahsildar, has recalled its earlier order dated 27/1982, wherein the land was recorded in my name. It is my submission, my Lordship. Under 38A, the same cannot be done. If at all it has to be done, it is under 38B, not 38A.
No. What seems to have happened, now you come to page 36.
My Lordship.
After the order was passed in 1992,
my Lordship,
a correction was still effected in the ROR in favor of the Gadadhar Naik, the petitioner.
My Lordship.
And it now says that that is in violation of the earlier order.
Yes, Your Lordship.
And therefore,
my Lordship, I can understand that. My humble submission is, my Lordship, if the Tahsildar has passed an order in its own wisdom, can under 38A the same can be recalled without going to the higher authority, Your Lordship, under 38B. That is the Board of Revenue.
Yeah, anyway, I think both these orders are completely outside law. Yes, Mr. Mishra. What is happening here, Mr.
No, actually, what with due respect, my lord, what has been projected actually is not the exact fact. Lords, you kindly see, there is a circular of the government actually is this endowment authority that Bhagavati Endowment is the intermediary.
All right.
There is a trust state declared under section 8B of the OEA Act. These are trust estates after vesting, and they are supposed to file application under section 6 and 7 for settlement.
No, but anyway, Mr. Mishra,
yes, madam.
This person was never heard.
No, he was heard, madam. He was heard.
I was only heard in the.
But they challenged the order on 13B, 38B. They challenged the order before the authority.
That was filed by me before the Board of Revenue.
Just a minute, may I just request the council to just wait for a second? Actually, let me submit. But if your lordship looks at government issued circular that the intermediaries whose the deed is property which is declared as trust estate will be granted an option to file an application for settlement of the land on the lease principle. But on that basis, an application was filed in 1981 because the 80 circular was there. 81, the property has already been settled in favor of the deity. I have filed an additional affidavit if your lordship looks at 33, 2011.
No, I'm on this one question, Mr. Mishra.
Yes, madam.
If you come to the order dated 29th April 1992.
Yes, madam.
Page 30.
Page 30, madam.
What is there in this order to show that notice was issued to Mr. Gadadhar Mahapatra and he was heard? What is that to show that notice was issued and he was heard?
Sir, exactly that is the point what your lordship is asking. The same question was raised before the Board of Revenue and the member Board of Revenue wanted the file to be produced. But it has been found that the bench clerk who was there, a fraud has been considered, fraud is there.
Whatever, sir, the greater fraud you claim, then the more the requirement for national justice.
I'll just show your lordship that the member Board of Revenue has dealt with those matters.
No.
Kindly have a look at.
All right.
The order, right, Annexure 5.
All right.
He was never in possession. He was never the tenant. He is a homestead land. If your lordship kindly look at page 39, top minute.
So right now, who's in possession?
So actually, sir, it is a house. It's a house with bagayat, means the orchard.
It is a status quo order is operating your lordship. My dwelling house is there. I am inside.
It's a house, residential house.
What is the date of my dwelling house, your lordship?
Sorry?
It's my dwelling house. I'm staying there, your lordship.
No. What is the date of the status quo order?
My lordship.
I don't think there is a status quo order. Right. There is a status quo order.
Sir, kindly have a look at page 39, Marad.
No, Mr. Mishra, then this is plain now. All right. There is a status quo order from 4th February 2009.
Yes, Marad.
So let this go back to the first authority before whom you filed the review. We'll have a time-bound disposal now.
But actually, it's a recall application, though it was mentioned review. He has considered it, Marad. But the Board of Revenue has dealt with each and every point that is raised before your lordship.
Sir, we are on jurisdiction, correct?
Yes, jurisdiction is there.
No.
The fraud has been practiced.
Fraud is one part of it, sir. But under 38A, there is a limited power for review.
But that has no review application. Actually, that is not a review application. To recall the order, the court has dealt with the matter. If your lordship looks at, it has already, the property of the DT has been settled way back in 1981. He has suppressed everything. Kindly have a look at the order. Mother.
Can I add this on one point, your lordship?
No, just a minute, sir. Sir, kindly have a look at that affidavit I have filed. Annexure D/1. So kindly have a look at that. It's a DT's property. Endowment was not noticed, and the inspector of endowment was called to address, but the executive officer is there of the endowment.
No. What happens is this, Mr. Mishra. Even when this order of 1981 is passed,
yes.
If you look at the order, it is some suo motu proceeding. All right.
Yes, sir.
So nobody is heard. Simply when report is called for, one entry is made. Now it is deity's property.
No, 81 notice has been given, Marad.
Where do you get that? Where do you get that?
Sir, it's mentioned there. If your lordship looks at,
let's see.
So what the proceeding is started on the report of the record keeper. It reveals that the status of the following land is DL Bahali. Nija Dakhal means is physical, own possession of the deity. and the land is recorded in the name of the
This is the
Dakhineswar.
ultimate order, sir. I'm asking you a simple question. Before this order was passed in 1981.
Yes, but kindly look at page 6. Issue public proclamation inviting public objection, if any, fixing the case to 18,981.
Right.
The public proclamation was there. The RI Bandpur was inquired into the matter. Thereafter, it was posted for further hearing. Every date I have given each one of the date. SR of proclamation received back after service reminded the RI concerned to submit the necessary report. Then SR of notice so-and-so also report from RI concerned received. Issue fresh notice to the Commissioner of Endowment Bhubaneswar. An inspector of endowment Bandpur is appeared before the court on 2011 to 81. Report of RI not received, and again report was submitted. RI, if your lordship looks at once the Basant Kumar Mahapatra appeared, he is the person actually. Basant Mahapatra is related to Gadadhar Mahapatra. He appeared, I am busy in the office, so neither the objector nor any of this representative found present. Then if your lordship looks at then 11/11/82 proclamation received back after due service. No objection received. Though the stipulated period is over, heard the party present, report the RI received, peruse the same. Then report of RI reveals that the case land is Debottar Lakhraj Bahel. That is Nizdakhal land melod. Once the Dakhineswar Bhagavati Marfat Trust Board is in khas possession, physical possession of the case land and recorded RT land, this is recorded tenant land of such status vested with the state in 1963. Hence, it is ordered that the case land below is settled with name of settled with a right of occupancy subject to payment of back rent, says from the date of vesting 63 salami, which is equivalent to this time, the rent, etc. But this property is within that. When it was brought to the notice of the authority that they have taken an order, an application to recall was filed, and that application was taken up. So there was direction was that but if your lordship looks at the order of the member board of revenue, so kindly just take note of one paragraph, Ballard. At page 39,
yes,
in the middle portion,
yes.
Before proceeding further, well, I got that before it started in the middle of about 20 lines after.
Yes.
Before proceeding further with the facts of the case, it is relevant to mention here that the hearing of the revision in my court was held up for non-submission of the record of OEA case 95/87, and it was reported by Tahsildar Bandpur in his letter dated 31/12/1995 that the case record has not been handed over by one Sri Brajabandhu Subudhi, the then senior clerk of Bandpur Tahsil, who was presently working as senior clerk in the office of BDO Ranpur. I had noticed Sri Subudhi to appear in my court on 23/2/96. Tahsildar was also directed to produce relevant record on that date. On verification of the records of the movements of papers, I come to a prima facie finding that the Subudhi has been in custody of the case record, and after it was missing, taking into account the entries in the relevant register dealing with the movement of the case record, the Tahsil office I had directed Collector Nagar to, in my order dated 23/12/96, to place Subudhi under suspension and proceed against him departmentally. That was done with the hope that that faced with the ultimate prospect of major penalty in the department proceeding, the record may come to light eventually, but had not happened yet. One has to take the story further on the basis of certified copy of the order sheet and OEA case 95 of
file itself goes missing.
But,
so the file itself has gone missing.
Yes, that file from that after the order was passed, it was taken away. But if your lordship looks at, the court has dealt with every point and has held that it's a trustee state, it's an endowment property, nobody can claim right over the same, and therefore directed that the order that was passed, the record is missing, and he opened another case record on the basis of the certified copy that was produced. And it has been noticed that everything has been done in a surreptitious way without the knowledge of the endowment authority. The previous order that was recalled, and the subsequent order has been passed. But if your lordship kindly turn to page 42, my lord. Page 42.
Yes.
Middle portion. But every court has inherent power to recall. This has been laid down by the Honorable High Court in OJC so-and-so in the case of Sadhu Charan Viswar versus Commissioner of Settlement. To quote the word of the Lordship, but at the same time, it is too well settled principle that every tribunal has its inherent jurisdiction to recall the earlier order passed by it if it is satisfied that the earlier order was sustained by misrepresentation or fraud or certain patent error has been committed by which it was caused gross miscarriage of justice. In view of such pronouncement, Honorable High Court of Orissa, it is clear that the additional Tahsildar, so additional Tahsildar actually do not have the power, did not have power to recall the earlier order dated 28/11/87. In such case was passed, though misrepresentation of fraud, if the order has resulted in gross miscarriage of justice. As I've already mentioned, in the original record of so-and-so is missing, the Tahsildar office and the person prime is responsible has placed under suspension by my order. In the absence of ordinary record, it has to go to the certified copy of the same. If your lordship turns to para 9, my lord, he comes to the merit, my lord.
Yes.
Coming to the merit of the case, revision petitioner, it is clear that the settlement of land with him has prime is illegal. This is because estate admittedly vested in government in 74 and an application of the present revision petitioner before the Lord Tahsildar in 87 did much beyond the statutory period. As such, the application could be treated as a fresh lease. The law is well settled that in a fresh lease case could be settled with the ex-intermediary or his successor in interest. The present revision petitioner is not the intermediary nor his successor in interest. Therefore, an application for fresh lease of the land could not have been legally settled. And the lordship come to a conclusion, if the lordship looks at, in this case, last paragraph 11, last portion, it is well settled that before an order is passed affecting person's right, title, interest, he is entitled to be hearing. In this case, I find from the order dated 22/8/95 that notices to Sarat Chandra Mahapatra, Gadadhar Naik, and Sadadhar Naik and Gadadhar Mahapatra, the present revision petitioner, and Susil Mahapatra were sent through registered post. These registered letters are also received by this person through Banpur sub-post office by the receipt number 4367, 4368, 4369. In reply, Susil Mahapatra submitted a petition stating that he has nothing to say as he was not a party in the original OEA case. The other opposite party, Gadadhar Naik alias Gadadhar Mahapatra, did not appear in spite of service of notice, receipt of notice. As such, it is not open for him to urge that the order was passed behind his back. He could not come and urge his case before the learned OEA collector come additional Tahsildar. He has chosen not to do so and therefore cannot complain that the impugned order has been passed behind his back. The very fact that the record of right was unauthorizedly and surreptitiously corrected on 19/9/92 and new khata so-and-so has been opened. In spite of order dated 27/6/92, the learned additional Tahsildar not to correct the record leads me to believe that such surreptitious correction of record of right might have been done at the instance of the revision petitioner because it was to his benefit. And accordingly, the court has dealt with the matter.
All right. Yes, Mr.
My lordship, I'll just submit one thing. If my lordship will permit, if I will submit.
Yes,
your lordship. The fact regarding that they have given an additional affidavit. They stated that the land has been stated in favor of the intermediary since 1982. Such fact, my lordship, can you see the impugned order, wherein they have stated that such fact has been in 1982, the land has been stated in the favor of the intermediary, lordship. Nobody has been dealt with, it has been dealt. Now coming to the fact of the fraud, your lordship. We are in under Anship 5, my lordship. It's a revision application filed by me under 38B. Under 38A, it is a review application filed by the intermediary, my lordship, where I have stated a single paragraph about fraud. or whereas or the OA collector at District Tahsildar, my lordship, under Annexure 4, whereas they have given a finding about fraud, your lordship.
No, the member board of revenue gives that finding.
That has been filed by me, your lordship. If I have
maybe. See, when whoever files it during the course of hearing, if the authority finds that the entire thing is based on fraud and suppression of material facts, he has to record it.
Yes, your lordship. But where has been recorded? It's not about how the fraud has been committed. It's not been stated, your lordship. Just because the file is missing.
The fact that the file itself has gone missing. From the photocopies, he finds entries have been made in favor of the deity way back in 81.
With due respect, your lordship, if in 1981 the land was settled in their favor, my lordship, if they could produce the documents here in the High Court, your lordship, what restrained them from producing such fact before the Board of Revenue, your lordship? Such fact has not been considered by the Board of Revenue. In 1981, the land was recorded in their favor.
Yes.
Let them show one paragraph, your lordship, from where they find a conclusion that I have committed a fraud. If the file
if the land already stands in favor of the deity way back in 1982, 81, where is the question of your applying for settlement in your favor?
My lordship, may kindly say Annexure 1. Annexure 1, page 23, your lordship.
Yes.
Sorry, page 22, your lordship.
Yes.
Issue general notice inviting public objection, if any, within 30 days after proclaiming the factum of the settlement of land in concerned Moja by beat of drum, and also issue notice to endowment inspector of Dakeshwar Bhagavati BJ at Banpur and Pati to appear before the court on 20/11/87 at 10 o'clock. In the meanwhile, ask Revenue Inspector Banpur to submit the necessary position report after visiting the spot by so and so put up on 20/11/87.
See, you have not been able to question the ROR in favor of the deity. That has remained in favor of the deity since 1981. That fact was suppressed. See, the question is, when you filed your application, either you deliberately suppressed or you did not make the effort to find out.
My lordship, it has not been suppressed because the then Tahsildar has asked for all the encumbrances of the property, your lordship.
Yes.
22. Even at that point of time, even also the notice was issued to the endowment inspector of Dakeshwar Bhagavati BJ. They didn't appear at 87. Page 22, can you see page 22?
Yes.
They never appeared. This is there in 1987, your lordship. And after 1991, they have filed an application of review or even a revision, your lordship, or review. For the same ground as 38A.
We are not convinced, Mr. Biswal. This seems much more than meets the eye, because once you knew this was endowment property, there's no way you would not have known this.
My lordship, I'm never. I'm not saying that much is endowment property because the same was recorded in my name after doing all formalities under the OEA Act, your lordship.
See, there has been some suppression somewhere. Otherwise, these orders could not.
My assumption is, my lordship, even if 38, even if this
it appears from what we see from the member board of revenue's order that after the ROR was entered in favor of the deity, the file itself was taken away.
Yes.
So when you file your application, the original file is not there. So it is proceeded with as if it's a fresh application with no contesting issues, with no competing interest.
The only aspect, my lordship,
yes,
the member of the Board of Revenue has given the decision on the certified copy filed by me. I have supplied every copy, every order which I have.
It's all right. It's all right. But if it's a fraud, it unravels everything. That doctrine is there.
But my lordship, there is no how the fraud is committed. My lordship, it has been described, your lordship.
No, nobody. As to even if you may not be personally responsible, somebody is.
Then my lordship, how should I can suffer, my lordship? I have not committed the fraud. I can see, give all the documents that we filed before your lordship.
I think it's not. That's neither here nor there. Sorry, we won't interfere, sir. We won't interfere.
And my lordship, my dwelling house is there since 1962, your lordship.
Maybe. So the status quo order stands vacated. The petition is dismissed. The detailed order will be passed. All right. Yes.
Item number 21, your lordship.
Press admission, item number 21.
Item number 21, Your Lordship, the cause of action does not survive anymore.
All right. Counsel, the petitioner states that the cause of action does not survive.
My appearance been noted, my lord. I'm for the OP number 3.
All right. All right.
Item 22.
No instruction, my lord.
Counsel, the petitioner states he has no instructions. Petition is dismissed.
Item 23. 23.
Pass over.
Item number 24.
My lord, let me take instruction, my lord.
For what?
Department
I have challenged the penalty proceeding where the tax has been deposited within 30 days. And I have also supplied the information as and when required by the ITU. And they have admitted the fact at page 21, Your Lordships. But still they have issued the so-called notice under Annexure 3, where they have stated that because the faceless penalty scheme has been launched from 12th January, so I have to again submit all these documents through portal, Your Lordship. But the fact is that
See, he wants time for instructions. You say Mr. Chimanka, who appears on advance notice, seeks time for instructions. List on 8 March.
Yes, ma'am.
till that, Your Lordship.
Yeah, till then, no coercive steps be taken against the petitioner.
Obliged.
Item 25.
You just said, in fact, you say notice, he accepts notice for the department and seeks time for instructions. All right.
Item 25, sir.
Wait, please, my lords. Lordships, I am appearing on behalf of Mr. H. Mohanty, my lords. Lordships, we want to withdraw this.
All right. Counsel, the petitioner seeks leave to withdraw the present petition.
And liberty may be granted, my lords, to this
liberty.
court with better application, my
No
lords.
liberty. No.
It's purely political.
Notification. Yes, absolutely.
Lordships, at that time, we have not complied with Rule 8, my lords. But in the meantime, my lords, we have complied. So we just want to file a better application, my lords.
No, my lord, let me tell you, Lordship, there's a problem here. This is a politically motivated petition. And the petitioner number 2 is the district president of one of the national parties. Lord, I don't want to take names.
Right.
And the state president has already moved the commission for National Commission for Scheduled Caste Tribe, whatever. This is all.
All right. In fact, the affected parties can themselves file.
Lordship pleases.
Yes.
Yeah. Counsel, the petitioner seeks leave to withdraw this petition, dismisses withdraw. Right.
Item 26.
26, may I please, Your Lordship? My Lord, Your Lordship, may kind come to page 30, Annexure 6. My Lord, I have a limited grievance that representation may be considered. Page 30, Annexure 6.
Was this delivered, sir? Is there a proof of delivery of this? Only, okay, postal receipts.
Yes.
All right. The petitioner's representation dated 30th March 2021 shall be considered by the opposite party number 2.
2, my lord. No.
Yes. OTPCL. Opposite party number 2. That is Chairman cum Secretary OTPCL, Department of Energy. And after giving a hearing to the petitioners, an appropriate order, reasoned order shall be passed thereon, not later than 2nd May 2022, and communicated to the petitioners not later than 9th May 2022. The court clarifies it has not expressed any view on merits. The petition is disposed of.
My Lord, I may pray, my Lord, that may be disposed of within March. May is.
No. Sir, there are enough work for all of them.
All right.
All right.
Item 27. Item number 27.
May I please, Your Lordship?
Yes.
Miller, in this the villagers of Daltona village and the nearby villages filed a writ petition challenging the inaction of the authorities by not allocating the earmarked and reserved plots in the name of the hospital and by not evicting the encroachments.
All right. You say the petitioner's representation
Miller,
dated 30th March 2021.
Yes, Miller.
Considered by the principal
Miller. May I submit, Miller, one thing, Miller? since 2004 and 5 onwards, we are time and again filing representations, and on 30th March 21, we have filed.
Sir, we are asking them to consider those representations. Is it okay to pass that order, or you don't want your representation to be considered? We are passing an order that your representation should be considered in a time-bound manner. Petitioner's representation be considered by the principal secretary.
Lord, may I request, Lord, the collector Khurda may be directed to consider the representation.
All right, by the collector Khurda, opposite party number 4.
May I submit, because collector is not the competent authority, Millard, your Lordship may direct the opposite party number 1 and 2 to consider the representation.
There are 2 principal secretaries, they can't jointly sit together to hear you.
Moreover, Millard, his main grievance is that the land has been occupied by encroachers. He has also not added those encroachers as parties to the writ petition.
Oh, I see.
Millard, my main grievance is your Lordship may turn to Annexure 1. That is the error made in the 2002 settlement. Clause number 171, page number 13, Millard. 171, 175, 223, 225 are reserved and earmarked for the purpose of hospital, Millard. Dr. Khana Nimante Sarankito.
No, come to para 4.7. Come to para 4.7.
Yes, Millard.
Just read that, sir.
That thereafter, in the efflux of time, major areas of the reserve plots for a hospital has been encroached by the encroachers for their personal gain.
Give us the names, sir. Give us the names of those encroachers. Where have you named them?
No, Millard, I have not.
You will have to name the encroachers, sir. That is the very basic requirement. Otherwise, it is not possible for anybody to pass orders.
Then
the petitioner seeks leave to withdraw this petition with liberty to file a fresh representation to the concerned authorities by naming the alleged encroachers on the plots stated to be reserved for a hospital, and after following up on such representation to seek appropriate remedies in accordance with law. This disposed of as withdrawn with liberties prayed for.
Item 28.
I may please, Your Lordship. The allegation of the petitioners are one of the is the senior citizen, and second is the journalist, and third is the local man, my lord, and fourth is an NGO organization. As well, the opening of one IMFL ONSAF means where one can consume liquor within the Bhendi premises. That is called ONSAF.
Thank you, sir. Thank you.
I'm sorry, my lord, to clarify.
No. I'm sure your intention is a good one. All right.
No, there is a difference between ONSAF and OPSAF.
Very good, sir. Very good. In fact, we need this education. We need this education. Yes.
No, I wanted to say before Lordship because one can consume the liquor within the Bhendi premises. Yes, therefore, in the village residence area,
right,
without asking objections or making a frivolous consideration without giving public notice, they have started opening a IMFL ONSAF.
All right.
From the village where school, colleges, and temples, everything is available within 100 meters.
No, but there is a procedure under the Act, no, sir? For
yes, my lord.
No. Did you respond to the notice and did you file objection?
Exactly. It was never communicated. It was never widely published. It was never widely published, never communicated. We'll also look at all the documents we have bought through RTI Act.
All right. What we'll do, sir, we'll just issue notice, let them file a reply.
All right, madam.
You say notice. Mr. Monty accepts notice for the opposite parties. 1 to 4. Notice be issued to opposite party number 5, returnable by the next date by registered speed post. Tracking report be placed in record. The specific allegation of the petitioners that there was no notice, public notice issued for opening of the single courts on shop in question shall be answered by the official respondents 1 to 4 with reference to the records by filing a proper affidavit within 4 weeks. Rejoinder thereto, if any, be filed before the next date. List on 9th March.
May I pray for status quo, my lord?
No, sir. No.
As your lordship pleases. As your lordship pleases.
All right.
Orders item 29.
May I please your lordships, my lord? This is a matter, my lord, where the petitioner challenges the non-allotment of vacant land under 17th point program of the state government floated since 1996, my lord.
Yes.
This is the fourth round of litigation, my lord. Petitioner in the year 2003 applied to the Tahsildar for in proper form, my lord, to granted a lease of record 6 acres of land for development of green farm, my lord. The petitioner, as the Tahsildar didn't consider, and the Tahsildar filed Annexure 2, stated to the petitioner that you apply in a proper format with the documents, my lord. In hope that, my lord, the petitioner applied to the Tahsildar in proper
this
form.
19th June 2008.
Yes, my lord.
Where at 10 you have set out an order, 19 June 2008.
Yes, my lord.
What happened pursuant to that order, sir?
19th June 2008, my lord, pursuant to that order, as they have not considered, I have filed the contempt petition, my lord. But when I have filed the contempt petition, my lord, the Tahsildar hurriedly disposed of the lease case, my lord. I have avoided in my page 6 at para 11, my lord.
No. So what is that order passed by the Tahsildar?
Tahsildar, that order, my lord, I have challenged in the writ petition, my lord. That order has been cancelled, my lord. By this honorable court by WPC number, the next para 12, my lord, WPC number 10308 of 2009, my lord. By this honorable court, if your lordship turn to page 7 at last paragraph, my lord, the Tahsildar Athagad filed letter dated 5/7/2003 to file lease application in proper form enclosing the operative portion of the order is at page 8, last paragraph, my lord. In view of the above case, the petitioner should have been forwarded to the expert committee, but without referring to the case, the expert committee, the Tahsildar has first impugned order rejecting the application of the petitioner. Therefore, we quash the impugned order and direct the Tahsildar Athagad, the opposite party number 2, to refer the matter to the expert committee, which may, after making necessary verification, submits its report. Accordingly, and on receipt of report, necessary order shall be passed on application of the petitioner, my lord. And after this, my lord, as the authority...
So 2013, some order was passed in your favor.
Yes, my lord. 2013, my lord, this honorable court, your lordship may turn to page 11, my lord. I have quoted that order, my lord.
Correct. Come to para 3 of that, page 12.
Yes, my lord. And the last, the operative portion is as page 12 as paragraph 3 of the order. In view of the above, this court disposed of the writ application directing the collector Cuttack, opposite party number 2, to consider the application of the petitioner for allotment of any alternative vacant land in his favor under the scheme for the purpose of raising green park and pass necessary order in accordance with law as expeditiously as possible, preferably within a period of 6 weeks. As they have not considered till date, I have filed the writ application in 2015, my lord. till the date, my lord, they have not considered, and they have stated that the land is not available. In by annexure 4, I have stated that the vacant land and the
what is so important about this green park? What is so important about this green park? Why do you want a green park?
Then, as the petitioner is a handicapped person and he has no means of income, my lord, applied the Tahsildar for raising
No. So, because of a green park, how will he get income?
Green farm, my lord, raising of fruit bearing trees, small bearing trees, my lord, apart by cultivating that, my lord, the petitioner will earn something and live his livelihood, my lord.
I don't know. It seems very strange.
That is the government program, my lord. Yes, my lord. 17th point program issued in 1996 by the government, my lord. State government, my lord.
Sir, this petition In the last 6 years, it has not even come up twice. And defect never removed. So how serious are you about this petition?
The defect, my lord, I'll remove the defect within 7 days, my lord.
No. It's not for that, sir. This is a 2015 matter.
Yes, my lord.
You don't seem to be serious about it, sir.
So I didn't know, my lord.
No, how can you not know, sir?
By filing of repeated memo for listing this matter, when the matter came, that is a
no, sir. This matter, let me just tell you, this matter has not got listed because of your memo. The matter has got listed because we've asked all old matters to be listed.
Because, my lord, I have filed.
There's no memo, nothing. They never removed the defect.
My lord, I have personally visited to DR and filed memos in the month of December, my lord.
Sir, I have been here since January 2021. All right. I have not heard you mention this matter even once. This has got listed on its own. Anyway, forget all that. What is this green park? What will you do on this green park? What are you supposed to do on this green park, sir?
I will do plantation of the fruit-bearing trees, my lord, and all others.
Where are you located, sir? Where are you located? You're in Cuttack.
Cuttack, my lord. Near.
So if land is not available in Cuttack, they give you land in Malkankari, what will you do?
Athagad, my lord. I have, if your lordship turn to page 23, I have given the ROR of the government, my lord, where
but they're not obliged to, sir. They may have so many other needs. They're not obliged to allot these kind of plots.
My lord, they have, as per the order, they have made an inquiry and submitted the report, my lord. And this court repeatedly by 4 petitions directed to consider and pass necessary orders to granting, my lord.
Even today, we will pass another order like this. You will keep coming every 1 year, every 2 years with the 6th writ petition, 7th writ petition.
If
it has no meaning. So this kind of, to please you, we can pass another order like this to consider your case. What does that mean?
My lord, what the petitioner will,
unless you have a right. No. See, 17-point program is not a statute which promises anything, correct?
No, yeah, that is correct, my lord. That is correct, my lord.
So it's all under the discretion. It's all in the discretion of the government. And you are not the only physically handicapped person in Orissa. So there must be many people with similar demands. So there must be some criteria. Some policy must have been framed for this allotment. If it is a discretionary allotment, there has to be some procedure devised for it. There has to be some procedure.
Yes, my lord.
What is that procedure?
Your lordship may grant 7 days time, my lord. I will collect the 17-point program and the procedures, my lord.
All this you should have done when you drafted the petition, sir. When you drafted it 6 years ago.
Yes, my lord.
You should have actually set out what is the procedure for allotment under the 17-point program. See, this is a writ petition under 226. Unless the procedure has not been followed, we cannot interfere. We cannot dictate to the government that you allot this plot and that plot.
Yes, my lord.
What is the procedure? The easy way out is to go on filing writ petitions and for us to go on passing orders saying consider this case. That way you're not troubled about looking into the law. We are not troubled about looking into the law. They are not troubled. So every 2 years we will pass an order saying consider this case. You are very happy, you have collected the fees from the client, you've got an order in his favor. Correct?
And
because you're not looking into the law. See, if you went strictly by the law, you would have by now known what is the procedure. You would have known what are the parameters of administrative law. You would have known whether the procedure was followed or not. You would have known that in the jurisdiction, the court is supposed to be looking into the decision-making process.
As per the government
the decision itself.
As per the government land.
I don't think you are worried about all this, Mr. JT. You are not worried about what I am trying to tell you, correct?
And I am worried.
I think I am wasting your time unnecessarily by talking law. You don't want all this law. You don't want to know about all this law.
Yes, ma'am.
So I think I'm troubling you too much.
No, my lord. Sorry, my lord.
Yes, I can see that. You're saying, what is this Chief Justice wasting my time talking to me about law?
No, not that way. No, not that way. No, not that way. I'm sorry, my lord.
No. I'm sorry that since petition filed since 2015.
What your lordship poses, my
this is
lord,
the
let me
fifth writ
grant
petition you
some
have
time.
filed, sir. Correct? This is the fifth writ petition.
Yes, my lord. Yes,
And
my
in
lord.
all these 5 writ petitions, there is no discussion of law. So every 2 years, we keep passing orders saying, consider representation, consider his case.
Your lordship.
What is the legal position, sir? What is the principle involved?
Your lordship may grant me at least 7 days time. I will appraise your lordship with law, my lord. Law and the required.
First of all, factually, sir, was there a procedure followed, not followed? What has happened?
It seems that they have not followed the procedure.
Not seems.
Government also not filed counter, my lord.
No notice was issued. Why will they file counter? No notice was issued. Because no effort was made to even get the petition listed. This time we can't blame the government for not filing counter. We have not, no notice was issued in the petition.
Lordship may say government to take instruction, my lord, to whether.
Sir, first of all, you have to do your homework, sir.
I will homework. Your lordship may granted 7 days time. I will do your lordship satisfaction, my lord. Homework
needs time to explain to the court both the factual circumstances as well as the legal principles on the basis of which reliefs are being sought in the present petition. At the request of the petitioner, list on 14th March. All right.
Deeply obliged.
Item number 30. Item 30.
Unmute yourself, Mr. Padi. Unmute your system.
Sorry, my lord. Kindly permitted to withdraw, my lord.
All right. Counsel, the petitioner seeks leave to withdraw this petition. Dismiss this withdrawal.
31.
Done. Yes. Anyone for 31? This person never appears. This particular lawyer.
He's dead.
Never appears.
He's dead.
I know. None appears. Dismiss for non-prosecution. Yes.
Item 32.
May I please your lordship? In this matter, my representation, my lord, while annexure 2 is pending before the collector, who is not taking any steps.
What is the matter about, sir?
Matter is that, my lord, a central government employee has filed a fraud affidavit, has filed an affidavit before the revenue authority, Tahsildar, wherein he stated that his income is less than 36,000. But he is a central government employee. Everything is written in annexure 1, my lord. Annexure 1.
How is this a PIL, sir?
That's why I'm saying, your lordship.
How is this a PIL? How is this a PIL? You should have filed a criminal complaint.
No. Your lordship, kindly have a glance to ground number F. Ground number F. We the local students are suffering, my lord, because of this kind of illegal orders of Tahsildar.
What is this? Why have you made a private party an opposite party?
Because he has get the benefit of that certificate, and we have been deprived.
I don't understand. What this ground F has nothing to do with this opposite party number 8.
Opposite part in 8. 3, your lordship.
Sir, are you appearing in writ petition 31951?
23979.
Oh, 32. Oh. Sorry.
That is item number 33, 31951.
Sir, can you tell us again the petition you are appearing in, Mr. Rayat Singh?
Yes,
I think 32, sir. 32.
That is 32.
32.
23979 of 2020. My read petition number.
So just look at the prayer, sir.
Yes. My prayer is that, my lord, a direction may kindly be given to the opposite party number 1 to initiate a proceeding against the opposite party number 3, who is a government employee.
Sir, I am a student of law, all right. I was a very weak student in law.
Yes.
So you will educate me now.
Yes, your lord.
If a crime has been committed, what is the remedy available?
I am no way I cannot do anything against them. That is my submission. I cannot do anything against them.
I see. I think I will give you fail mark. If I give you this answer, you will also give me fail mark.
No, why I am saying so? Your lordship.
I am law student, sir. We are both in BL class, okay?
Yes, your
lord. Both doing law course.
It's a
Somebody
public.
has come and told you, sir, a crime has been committed. So I am asking you, sir, as a citizen, what is your remedy if a crime has been committed?
Right. Your lordship, kindly have a glance to Annexure 1, Para 3.
Yes. You don't. No. Kindly answer, Mr. Rayat Singh.
Yes, your lordship.
I have asked you a question, sir.
Yes, sorry.
Kindly answer the question.
Yes. I didn't get your lordship. What is your lordship's query?
Now I'll ask my colleague, because my question doesn't seem to reach your ear. I'll ask my colleague to ask you.
If a crime has occurred, what will you do as a citizen? That's what my lord is asking.
I didn't get your lordship's query.
If a crime has taken place,
yes,
what will you do as a citizen?
I will inform to the concerned authority regarding the crime, my lord.
Concerned authorities? Who are the concerned authorities? Who
Opposite party number 1, collector.
What is the statute involved, sir? What is the statute involved when the crime is committed?
Statute is that if at all a crime is committed.
What if at all? According to crime has been committed, correct? Look at your prayer clause.
But I am no way involved with that crime, your lordship. I have no.
We're very relieved, sir. We're very relieved to know that. We're very relieved to know that. We're extremely delighted. We're extremely delighted to know that you are not involved in the crime.
No, I am not involved in the crime. I cannot do anything regarding the crime.
Before answering, listen to the question, Mr. Raj Singh. Before answering, listen to the question. In this writ petition, you have made an allegation.
If a public servant commits a crime, what is the statute involved?
I can't say.
Mr. Rayat Singh,
sorry, I can't say.
I confess to you, I'm a very weak student of the law. Now you're turning out to be a weaker student than me, sir.
Sir, my limited. What I'm trying to convey.
My knowledge is very limited, sir. So we want education from lawyers. Judges are presumed not to know much. Lawyers are supposed to be learned. All right.
Right.
So learned, you are the learned profession, you are a learned lawyer. I'm asking you, if a public servant commits a crime, what is the statute involved? He doesn't know.
Worst case, I would inform. I will inform the higher authority that he is doing that crime. Necessary action.
Sir, may I take the risk of asking you, where did you do your law from?
KMS Law College.
I am going to pass it over, Mr. Rayat Singh.
Yes, your lordship.
I'll pass it over. You just ask any lawyer in the bar. Chief Justice is asking me, if a public servant commits a crime, what is the statute involved? All right, we'll pass it over. You come back and tell us.
Yes, your lordship.
All right, sir. All right.
Item 33.
Item 33, Lord, But Lordship, call this matter next week. I am not getting my file. That is. But item 33.
Yes.
Sorry, Lordship, I pray Lordship, let it come next week.
What is the matter about, sir?
Sorry, I have displaced my file. That is the construction of HL bridge. That is illegal. They have.
Lord, the petitioner challenges that the bridge is being constructed over Gochar land, Lord. And therefore this PIL has been filed. My humble submission is, if at all it is being constructed over a Gochar land, then the Gochar land needs to be de-reserved. And the petitioner has that opportunity to raise those objections regarding de-reservation of that Gochar land before the competent authority.
Collector is the authority.
Yes.
Yes, the petitioner's grievance appears to be about a construction of a bridge on what he terms to be single quotes Gochar land. Counsel appearing for the state points out that if a bridge has indeed been constructed, and the land was earlier categorized as single quotes Gochar land, it must have been de-reserved for the purposes of the construction of the bridge, and any objection in regard to such de-reservation of land should be voiced before the collector. Stop. Leaving it open to the petitioner to avail of the remedy, as pointed out. The petition is disposed of.
Item 34. Item number 34.
Pass over.
Item number 35.
May I pardon, my lord?
Yes.
My lord, today I am not ready. Any other date, my lord?
No, tell us what it is about, sir.
File is available in Bhubaneswar, my lord. I am residing at Cuttack now due to some problem. Any other date, tomorrow or day after tomorrow, or any next week, my lord?
My encroachment, my lord, private opposite parties, they have also been arrayed as opposite parties, my lord.
And representation.
Yes.
This is proof of submission of representation is there.
My lord, file not available with me today, my lord.
So we are taking the trouble, sir. The file is available both of us today. All right, and it's also available with State Council. So we are only asking whether this representation you have made was served on the collector.
No such receipt.
There's no receipt of.
Next week, my lord. Pardon, my lord. Next week, any date, my lord.
So you do one thing, you make a fresh representation, and this time make sure that you get the proof of making such representation.
My lord, if you representation file, the collector can consider on merit.
So you make sure, you say there's nothing to show that the representation dated 3rd December 2020 was in fact made to the collector Kyonjar. Consequently, the court is unable to pass any orders in that regard. Nevertheless, it will be open to the petitioners to make a fresh representation.
And if the name of the encroachers may
following, giving the names of the encroachers, alleged encroachers, and after following such representation, to seek appropriate remedies in accordance with the petition is disposed of in the above terms.
I may be targeted by the representation file.
No, so first you make the representation. All right.
Item 36. Item number 36. Number 37.
My lord, I am on behalf of Sangram Mishra. May kindly be granted 2 weeks time to remove the defects.
All right. Sir, these are. Do you think these are matters in which a court can get involved?
Sir, my senior is suffering from fever last 3 days. Since last 3 days.
You see this item. 1 minute, sir. 1 minute. Okay, you say list after removal of defects. Yes.
38.
May I please, Your Lordship? My Lord, this is a PL public interest litigation petition, my Lord. The road, that is a public road, it is situated in the Kotak Municipal Corporation, ward number 17. That has been encroached by some.
So there are so many defects, 4 defects pointed out.
My Lord, I may be permitted to remove the
list. Sorry?
Within a week, my Lord.
All right, list after removal of defects. All right.
Item 39. Item number 39.
My Lord, 38. Please, Your Lordship, item 39 not pressed.
Counsel petitioner states he is not pressing this petition. Dismissed is not pressed.
Item number 40.
Okay.
Item number 40.
Pass over.
Item 41.
Pass over.
Item 42.
My Lord, may I be permitted to withdraw with the liberty to file better application, my Lord?
All right. Counsel, the petitioner seeks leave to withdraw this petition. With liberty to file a better petition.
My Lord, item 41, my Lord.
This prayer is in 41?
Yes, my Lord. Item 41 is my system on it.
Sorry.
So what is your submission, sir, in 41?
41 is a PL, my Lord.
Yes.
My Lord. My Lord.
Yes.
Carry on, sir.
Yes, my Lord. Item 31, my Lord.
Correct.
Yes, my Lord. It's a PL, my Lord.
Yes.
The villagers are the tribal people, my Lord. They are the aspirant candidates for the Indira Awas Yojana. My Lord.
So this you have to go to the Lokayukt, sir. For misappropriation of public monies by a sarpanch, you can go to the Lokayukt. Okay.
So I have communicated to the collector Kenya.
No. You have to go to the Lokayukt, sir. For all this misappropriation of public money and all that, you go to the Lokayukt. You say, given the subject matter of the petition and the complaint made therein, the court permits the petitioner to approach the Lokayukt in accordance with law. The petition is accordingly disposed of.
Item 43.
42 is called out.
Wait for withdraw.
So that you passed 42?
That is already.
Item 43. Item number 43.
Pass over.
Item number 44.
May I please, my lord?
Yes.
Here, my lord, the petitioners are residents of village Raitala, Singha, Koyekoda, of Roitala Gram Panchayat under the district of Denkana, my lord. Here, the present petitioners, my lord, they are challenging the reorganization of primary agricultural cooperative society limited, my lord, from Santapur PACS to Boinsia PACS on the ground, my lord, that the proposed PACS is about 12 kilometers away from the villages of the petitioner, and the road passes through forest, my lord, to reach there. By our objection has been considered, my lord. Page 12 is the order, my lord. Page 12. We have raised objection, but our objection has not been considered.
Let's see that. Let's see that.
My lord, page 12, my lord.
Yes. Whereas objections are duly considered. Read from that paragraph. Whereas
page 12.
Yes.
First, second, third, fourth paragraph. Whereas the objection received from the members of Raitala, Singha, and Koikela villages under Roitala GP of Santapur PSS are not justified, as people used to go Gram Panchayat headquarters for various needs, such as PDS ration, old age pension, etc., and making PSS quarter manas with Gram Panchayat will enhance administrative convenience and conversion of various government schemes and programs, etc.
No. So what is your objection, sir?
My lord, my objection, my lord.
See, when there are several villages in a Gram Panchayat.
No. Yes, my lord, yes.
There are several villages in a Gram Panchayat, correct?
Oh, yes.
So the PACS can be only situated in one place.
Yes, it was.
It may be close to some Gram Panchayat.
It was functioning
villages,
since
it may be far from some villages.
last 65 years. It was in functioning in Santapur, which is only 2 kilometers away from our villages. My lord, a detailed representation kindly see. Page 15 is the English translation, my lord. Annexure 2 is the representation, and English translation is at page 15, my lord.
No, sir. It is bound to be closer or farther. So for some years you enjoyed some within 2 kilometers. For some other village, it must have been far away. Now it will be closer to some village and far away from your village. This is bound to happen, sir.
My lord. After this, my lord, Annexure 3 kindly see, my lord. The Annexure 3, page 24, my lord.
Yes.
Topic number 2 as given later to the OP number 4 to Annexure 3, page 24, my lord.
Yes. Yes, please.
Here, my lord, the OP number 2 has referred the representation of the villagers to OP number 4 to reconsider the grievance of the petitioners, my lord.
No, but you already had a full round, sir, with the registrar. You've had a round with the registrar. That's how this order dated 8 May 2020 was passed, correct?
Yes, my lord.
Your objections were considered.
Objections was not rightly considered. Our ground is, my lord, objections are not rightly considered, my lord.
No. What is rightly and wrongly is the question. How far can the court interfere?
Earlier, I have filed this application, my lord. Your lordship was about to notice and given a stay, but since our prayer is different, my lord, I have taken liberty to withdraw the application, my lord.
No. I still want to know, sir. See, the order is at page 11 and the reasons are at page 12. And this is about reorganizing of the PACS.
In respect of our villages, is at page 12, my lord.
Correct. So these are primary agricultural cooperative societies.
Yes, my lord. So the ground is, my lord, the most members, my lord, in this Santapur PS, my lord, most of the members belongs to the present villages, my lord. This my lord, these villages, Raitala, Singha, and Koikida.
Correct.
Most of the member of this primary cooperative society, Santapur primary cooperative society, my lord. Correct. Most of the members belong to these villages, my lord. And now, my lord, these villages are now reorganized in Boisia PACS.
So they want to have the PACS where the Gram Panchayat office is. So you belong to the Santapur Gram Panchayat. So PACS is kept in Santapur. This is like capital of a district, sir. The headquarters of a district.
My lord.
So the collector's office will be in the headquarters. The district judge will be, the district court will be the headquarters. It is bound to be close to some place and far away from place. As a policy decision, they've decided to locate PACS wherever the Gram Panchayat is, the headquarters of the Gram Panchayat.
Lord, since last 65 years, it was functioning in Santapur. And these villages, my lord, these villages are.
If it is a policy decision, I don't see how we can interfere, sir. Because what will then happen is every other village will start demanding. They will say, no, for me it is 10 kilometers. Somebody will say, no, for me it is 8 kilometers.
And the main problem
is, if we agree to those villages, some other villages will say, till yesterday it was 2 kilometers from our place, now it is 10 kilometers.
No other villages, my lord, they have not raised any objection. Page 11, page 11, my lord. My lord, page 11, 85/2020, that order, my lord.
Yes.
Many villagers have given objections, my lord, and all of the objections have been considered, but our objection is not considered in respect of our villages only. Page 11, my lord. Page 11, regarding reorganization, all other villages also given objection, and their objection has been considered. Only in respect of our
considered meaning what? Have they reversed the decision?
Yes, my lord. Yes, my lord.
Where is that? Where is the odd decision reversing that?
Reversing decision has not been during, my lord, page 11.
No.
First, second,
decision
third.
At page 11, you say has been reversed for some other villages.
Their objection has made justified. It has been written, and their objection raised by the villages are genuine, and accordingly this has been passed. But in case of our
No. Let's be clear. Let's be clear.
My lord.
This order of 8th May 2020.
My lord.
Has it been reversed or modified in respect of some of the villages?
My lord, this has been after inviting objection. This order has been passed, and this.
Sir, I'm again making. If you're not able to understand my question, I'll request Justice Mahapatra to ask you.
No, my lord.
Let him ask you. Let him.
After considering the objection, have they reversed their decision in any case?
Earlier, no.
Saying this order has been passed after considering the objection. Is it your case that they have reversed the decision in respect of some of the villages?
Earlier, what I may not.
No, give a straight answer. Don't beat around the bush.
Earlier, my lord, objection has been invited.
Have they reversed their decision in respect of any village where earlier they had taken a decision to set up this PSC office?
Earlier, this PS has not been made. After getting the objection only, this order has been passed. So earlier,
no, but after considering the objection, have they reversed their decision in respect of any village?
That is not.
That you don't know.
That
you don't know. You have no such instruction.
Yeah. So why should we interfere, sir? Why should we interfere? It's a policy decision that they want to locate the PACS at the Gram Panchayat headquarters. You say the grievance.
What I pray, my lord, this order is appellable one. I have to verify that. So
then you withdraw the petition, sir. If you want to seek other remedies.
My lord. Actually, Mr.
If you want us to pass an order, we are not going to interfere. If you say, let me take a chance with some other authority, we are not going to stop you.
My lord, I only pray, my lord, matter may be on next week that it may be taken.
Not like this, sir. Not after 10 minutes of argument. No.
Is it applicable? Have you verified?
I have not verified. That's why I'm.
We'll pass it over. You verify. Yes.
Item 45. Item number 45.
My lord, some defects have been cropped up in this filing of a writ application.
All right. List after removal of defects.
I will be permitted to remove the defects.
Yes.
Item 46.
Item 46 permitted to withdraw.
Counsel, the petitioner seeks leave to withdraw this petition. Dismiss this withdrawn.
Item 47.
Lordship, in this matter.
47.
Who's for the petitioner?
Item 47.
May I please, sir? Because in this matter there is some defect, so kindly allow me some time to remove that defect.
All right, counsel, we say list after removal of defects.
Item 48.
May I please, Lord? My lord, the petitioner, my lord, the villagers of a Gram Panchayat, Lordship, can see Annexure 1, page 17, my lord. The government decided to have a.
So there are so many defects.
There are 2 defects, my lord, between 6 and 22, my lord.
Yeah, 3 defects.
6, 11, and 20.
List after removal of defects. All right.
ହେଲା ସେଣୁ କରିଦେଇଛନ୍ତି ବୋଧେ ଅନମ୍ୟୁଟ ଅଛି ଆପଣ ଏଟା ଘଟର ହାତ ମାରନ୍ତୁ
ଘର ତ ନାହିଁ ବର୍ତ୍ତମାନ
ସେଣୁ ଅଛି ଠିକ ଅଛି ସେଣୁ କରିବେ
Am I audible, my lord? My lord, beg your pardon, my lord. Without considering the archaeological hill, my lord, the government has granted mining lease in favor of Orissa Mining Corporation, that is opposite.
1 minute, what is this defect 22? What is this defect 22, sir?
My beg your pardon, my lord.
Defect. Rule 8 is not. You have to comply with the rules, sir. Rule 8 you have not complied
PIL
with.
rules. PIL rules.
Counsel, the petitioner seeks leave to withdraw the present petition. When did you make this representation?
Yes, I have made a representation.
No, when? Only on 7 January.
My lord. So it is get to the public domain of late, my lord. That's why you gave the representation immediately. So it was not brought to the notice of the community, or it was not in the public domain.
This representation you made only now, 7 January.
My lord.
You have to wait for some time, sir. We are not even 24th January.
Actually, they have made preparation for mining. That is really, it is not brought to our notice. So that's why we immediately gave and filed.
Whatever, sir.
They have already made preparation for mining operation. That is why we are feeling it very urgent, my lord.
Sir, what is the kind of representation you have made? Come to page 28. What is the last 2 paragraphs? What is all this going on? You are not serious.
That's good. My lord, this hill is enriched with Buddhist monuments, my lord.
No, so sir, what are you trying to say? Look at the paragraphs. They are not serious. Did you draft this representation?
My lord, page.
How can you say these kind of things, sir? He's not got page 28.
The organizations, they have given the representation to the authorities, my lord.
Sir.
One Buddhist organization, they have given a representation.
Have you seen what you have said in your representation? Just see the last 2 paragraphs.
Kindly refrain from such Taliban-like venture for the sake of our rich history.
What is this? So, are you wanting them to take you seriously?
Beg your pardon.
Please don't say anything and everything in a representation like this.
Actually, my lord, the organization, on behalf of the organization, they giving the representation, my lord.
You are only that organization, sir. You are Mr. Bhuya.
He is the president.
You are only president of this organization. In fact, I don't know whether you should be appearing. Are you appearing in person or as a lawyer?
No, I have not filed the PIL, my lord. The vice president of the organization, she has filed.
No. This representation is made by you.
Your name.
Representation, I have given the representation.
Under your signature, this has been given.
So this kind of representation we will not entertain. All right. This is all irresponsible, very loosely made. Are you serious about this? What you are saying? Have you applied your mind and you are still saying this?
Withdraw this and file a better representation.
And be serious about it, sir.
Use some civilized language also.
Yes. Counsel to the petitioner seeks leave to withdraw this petition with liberty to file a proper representation in the first place, in proper language, highlighting the factual and legal issues involved. And after following up such a presentation to seek appropriate remedies in the court. This post office withdrawn with liberty.
Item 50. Item number 50.
I mentioned Narayan Chandra Jana. Namaskar. देखो कोविड रो भयावहता बर्तमान सारा देश तथा राज्य रे बांटी चलछि
No, it's not COVID.
साधारणतः गां लोक माने
Just tell him it's not, everything is not COVID, everything is not COVID-19.
Permit me speak in Oriya.
Yes, we can understand.
सुनाई भले माडी आसुछि तेनु ए परिस्थिति रे इलेक्शन न करी घुचेई दिया जाऊ तीनटा स्तर एटा शेष लहर होउछि कोविड रो तेनु जनसाधारण जीवन रक्षा करिया होउछि प्रथम कर्तव्य मान्यवर अदालत को पाखरे निवेदन करछि जे साधारणतः गां लोक मानकर सुरक्षा देई देश को बंचांतु
निर्वाचन कमिशन राज्य निर्वाचन कमिशन सब जिनस आखि रखी डिसीजन नेबे कोरोना कोविड रे कोन हबो न हबो ये कोविड नुओ जेतबेले ताकर निर्वाचन हबो से ताकर सब जिनस आखि रखी डिसीजन नेबे.
No, and he made this representation only now.
सर वर्तमान जेमति देखुति इलेक्ट्रॉनिक्स मीडिया रे चारियाडे लोक
He made this representation only on 17th January.
तेनु वर्तमान टिके किछि
when did he make केबे दैथिले रिप्रेजेंटेशन केबे दैथिले
17th January, page 15.
19-1.
So he is not even waiting for 5 days.
तेनु टिके घुचेई देले किछि असुविधा हबनी आज्ञा तो मोर निवेदन कुछि मानव अदालत को
having made a representation to the State Election Commission only on 19th January 2022.
17th January.
17th January, 19th he has to sign. Dated 17th, he has signed on 19th.
Yes, my lord. Yes, sorry, my lord. 19th, another.
The petitioner has rushed to this court without awaiting the response of the State Election Commission. You see, 17th/19th. Without waiting for a response to the State Election Commission. Full stop. Therefore, the court is not inclined to interfere at this stage. It will be for the State Election Commission to consider his representation. In accordance with law, the court clarifies it is not expressed in the matter.
Passed matter.
The petition is disposed of. Yes.
Passed over matter. Item number 23. Item 23.
None appears despite a passover. Dismissed for non-constitution.
Item number 32.
May I please your lordship? In this matter, as I have verified, my lord, section 197 prosecution, sanction of prosecution is there, PC Act is there. The remedy available before me is that I can go and approach the local and local under the local.
All right. So,
20, section 20.
All right. Counsel, the petitioner seeks leave to withdraw this petition with liberty to seek other appropriate remedies as may be available to the petitioner in accordance with law. This post office withdrawn with liberty is paid for.
Item number 34.
Obliged, my lord.
Item 34.
None appears despite a passover. Dismissed for non-prosecution.
Item 36.
None appears despite a passover. Dismissed for non-prosecution.
Item number 40. Item number 40.
None appears dismissed. None appears despite a passover. Dismissed for non-prosecution.
Item 43.
May I please, my lord?
Yes, please.
My lord, the petitioner filed this PL petition before this honorable court. So some government land encroached by the unholy illegals, and they have
who are these encroachers, sir?
The outsiders, my lord.
They have names or they're simply
yes.
They're Mr. Mrs. outsiders.
I give the names of any representation, my lord.
No, where are they made as parties?
They have encroached the government land.
Sir, come to the cost title. Come to the cost title.
My lord.
Which opposite parties are the encroachers?
I have filed the representation before the.
No. Please answer the question.
Yes, my lord.
Which of the opposite parties is the encroacher?
I have not met the party. There are several.
You have to make them parties, sir. You have to make them parties.
Yes, my lord.
Giving the details.
Yeah. Counsel for the petitioner seeks leave to withdraw this petition with liberty to file a fresh petition, properly naming the alleged encroachers and also having corresponding pleadings in respect of each of them. This post office withdrawn with liberty spread.
Item number 44.
None appears despite a parcel. Dismissed for non-resolution. Wait, what's that?
Yes,
My lord, item 44, that, my lord, PSCS case, my lord.
So where is he?
Item 44.
My lord, section 109 of Orissa Civil, that Corporate Society Act, my lord, provides appeal against that order, my lord.
Section 109.
Yes, my lord.
You say considering that the order dated 8 May 2020 is an appealable one. But there must be a limitation for that, sir.
Yes, 60 days, my lord, 60 days.
And then condonable.
Lord,
Section 5 will apply then. If there's no provision, Section 5 will apply. Just let's look at the language.
Lord, an appeal under subsection 1 shall be made within 60 days from the date of pronouncement of communication of the order or decision as the case may be.
No, so there is, the language is not as if it can't be, delay cannot be condoned, correct?
Yeah.
Reduce the amount. So we can apply Section 5. This is some other provision. All right, considering that the impugned order of the Registrar of Cooperative Societies is an appealable one. It's appealable before whom?
Lord, A, B, C.
Tribunal. There is a tribunal, is it?
Yes, but my lord, the tribunal only
Tribunal.
The order passed under clause E, F, I, J, K, L, M, N, and N1. But my lord, if section 109C says that an order directing reorganization or amalgamation under subsection 1 of 14A.
No appeal lies. Then appeal does not lie, sir. Then obviously appeal does not lie.
So other authority has been prescribed other than these clauses, as specified in clause 8.
So has any other authority been prescribed under B? 109 2B.
Section 2B, clause B.
2B.
is the T1 section. Under 14A. Put an order into 14A.
Yes, my lord. Order has been passed under 14A. Page 12.
Ah. Correct. Where is our Mr. Bera? Okay.
Mr. Bahadur.
Mr. Bahadur. All right, Mr. Bahadur had sought a passover to examine if the impugned order is an appealable one under the Orissa Cooperative Societies Act 1962. Utsav, however, he did not appear on second call. Paragraph Mr. Das, appearing for the opposite parties, points out that under section 102, 109 bracket 2 bracket A, read with section 14 capital A of the, read with 109 1 bracket C.
Yes.
And section 14 capital A bracket 1 of the OCS Act. The order is perhaps not an appealable one. So nevertheless, he also seeks time to examine whether under section 109 bracket 2 bracket small b, any other authority has been prescribed for hearing such an appeal.
Lord, just for 111, my lord, section 111 says that review can be made by the same authority. So if that can be done.
But again, this is a very limited thing, sir.
Right. Cannot change this decision. It's only for some errors.
And within 90 days.
90 days.
Yes. I will take instruction.
List on 22nd February. Over. All right.